All right, Robert Maurer, they're waiting for your client so they can swear him in.
Let me text him, Judge.
Okay, thank you. And then Kelly Piddle, who are you here for?
I've been right here, Your Honor. They just let me in.
There
All
we
right,
go.
Mr. Casablanca, I'm gonna send you to breakout room number 1 so they can swear you in.
Yes, ma'am.
And Robert, I'll send you to 1 just to make sure they have everything.
Sounds good.
Yes, sir. Oh, you put it out?
All right, Albert Charles, who do you have?
Yes, Your Honor.
Who do you have?
I have Deangelo Robinson.
Criminal trial division or family
I filed
violence?
some motion.
Is it criminal trial division or family violence?
Criminal trial division.
And Judge, we conferred last week. I set for a bond hearing.
Okay, all right. Just give me a moment. And Miguel Nahara, who are you here for?
Good morning, Judge. I'm actually here for a couple of things. One is a plea on Mr. Andrew Garcia, but I'm also here as pro tem on the motions setting, which is why I didn't put it in my name because I couldn't fit all of that.
Okay, and then
And that's with Mr. Piddle and I regarding Montez.
okay. All right, then Mr. Garcia, has he completed all of the paperwork?
I don't believe so, Judge. I signed it this morning, so I needed to sit down and go through it with him while he's at the jail.
All right, let me see where he is. He hasn't signed in yet, so as soon as he signs in, we'll take that matter up.
No problem, Judge.
And everyone just give me a moment. Neil Kalfas, who are you here for?
Judge, you beat me to it. I was just getting ready to change my name.
Okay, I'm gonna let you do it.
All righty. Darren Does, family violence, and it's a continuation of our bond hearing.
Okay, I'm gonna let you do it.
All righty. Thank you. Sorry.
Oh, no problem. Jane, David, Bill Davidson, who are you here for? Does anybody know who Bill Davidson is here for?
Mr. Montemayor, Judge.
Is it criminal trial division or family violence?
Family violence.
Your Honor, I'm sorry, I couldn't unmute. I have a plea that's ready for the DA to do the paperwork on, actually.
All right, I'm gonna send you and your client then to breakout room number 2.
Okay. I just don't think the DA is aware that we are saying yes to the plea.
All right, so as soon as they get in, we will know. Monica Guerrero?
I have a plea ready for the second trial case I have set for tomorrow on Adam Gonzalez. And I still need to approach on Talia Harris, who wants to talk to you and represent herself on this motion.
All right, so on Gonzalez, is your client in custody? Or is he on bond?
No, Your Honor, my client is on bond.
All right, Adam Gonzalez, where are you?
We just got off the phone. I was talking him through the paperwork.
All right, just give us a moment. As soon as we do that, we'll take that up.
My client's sworn. We're ready to go, Judge.
All right, as soon as they give me the paperwork, we'll take that up. James Toshi, you have Mr. Watson?
Yes, ma'am, I do.
Is there a prosecutor available for this motion quickly, please?
Marcus.
All right, thank you. Brenda, it's always nice to see people dressed for trial. All right, we're going to go on the record in 2021 CR 6431, State of Texas versus Andrea Watson. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
James Tochi for Mr. Watson, Judge.
And are you Andrea Watson?
Yes, Your Honor, I am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, ma'am.
Mr. Watson, do you have any objections to this proceeding by video?
No, ma'am, I don't.
All right, Mr. Toshi, you filed a motion to withdraw.
I did, Judge, and I think the motion itself is fairly self-explanatory. The basic legal reason I'm asking the court at this point to consider my motion is I think the lines of communication between myself and Mr. Watson have definitely completely eroded. They've fallen apart. I cannot and have not had any effective communication with Mr. Watson in several months now. We've had, I want to say, between 3 and 5 court settings, and he does always appear in court. However, the conferences that I've had with him have been on the Zoom platform, and he's very irate and very upset at me and constantly yells and berates me. And the last few meetings that we've had, it's just, he's been very upset that I have not been able to get his case dismissed. And I'm quoting, he believes he's entitled to a dismissal and it should have happened several months ago. I've tried explaining to him the legal and factual issues. I've been provided a copy of the discovery of a video that he's yet to see with me. I've urged him to come to my office on many occasions, and he has not done it, Judge. He's now in custody because of some bond issues he has with his bondsman, and I believe he's been there for a little over a month now. I haven't had any substantive discussion with Mr. Watson. However, I don't think he is going to object to my removal from the case. I'll let him speak to that issue, though. But basically, I can no longer effectively communicate with my client any longer. It's just a one-way shouting contest, and I cannot represent anybody in that capacity.
All right, state any objections?
No objection, Judge.
All right, Mr. Watson, can you unmute?
Ma'am, what did you say? I didn't hear you.
Oh, I asked you to unmute yourself.
Okay,
All right, Mr. Watson, how old are you?
I'm 59, ma'am.
All right, so let me just tell you, one of my number one rules in the 187 District Court is that everybody treat everybody with respect. Do you understand?
Yes, ma'am.
So what that means is there's to be no shouting at each other, because guess what? When you shout at each other, nobody hears. You understand?
Yes, ma'am, you're correct, but Mr. Dorsey is incorrect. The only time that me and him have ever had any type of shout or anything was the last meeting we was here, and the only thing I was telling him was, if I'm going to be accused, and he seemed like he's more on the defense side, on the prosecutor side than mine, and I said, if I'm going to be accused, get the guy that's accusing me, let's get him in court, because I have not done anything.
All right, Mr. Watson, let me explain something. Let me explain something to you. And this is coming from me, a person who's been a defense attorney and a person who's been a prosecutor. Number one, I could be wrong, but I don't think things have changed where defense attorneys have dismissals in their pocket and they just save it for specific clients. So they don't have motions in their pocket that will give you an automatic dismissal where they can just write dismissed and it's
Yes,
done.
ma'am.
Number two, usually what ends up happening is complainants don't come to court usually and normally. They come to court at trial. So when a jury is sitting in the jury box, then that person comes in and that person comes in to testify. Do you understand?
Yes, ma'am.
All right. So here's the thing. This is your second attorney.
Link keeps taking.
I'm going to allow him to withdraw. But what I'm telling you this, and I want you to internalize what I'm saying. I'm going to appoint another attorney. That will be the last attorney that will be appointed for you, because this will be the third attorney.
No,
So
this is
what
only
is going to end up happening is that if there's an issue with the third attorney, then you will either hire yourself an attorney or you be representing yourself. But most definitely your case will be going to trial, whether you have the attorney there or not. Do you understand?
Yes, ma'am. Who was the first attorney?
All right, so, Mr. Toshi, your motion is granted. Ms. Ferguson, can I have a date in 2 weeks for Mr. Watson? Your new attorney is going to be Denny Callahan.
Your Honor, can I find out who was the first attorney?
Mr. Watson?
Yes,
This is
ma'am.
what's happening. Norma, can I have a date in the chat box? 2 weeks, please, for Mr. Watson. Mr. Watson, your
Yes, ma'am.
attorney is Denny Callahan. We're going to come back on April 18th. And if there are any issues with that attorney and you decide, or he can't represent you, then you will have to hire your own attorney or either represent yourself. Do you understand?
Yes, ma'am. Is it something wrong with me asking who was the first attorney was? Because
We're done.
Yes, ma'am.
Thank you. See how
Bless your
easy that
heart.
is? Yeah, bless your little heart too. All
Yes,
right,
ma'am.
Norma, Mr. Watson, 17B is going back. I'm from the South, so I understand Southern expressions, Mr.
It says
Watson.
here,
Bless your little heart.
mute, and then it says
Thank you, Judge.
You're welcome. All right, thank you, Mr. Toshi.
audio. Switch to audio.
May I be excused?
Yes, you may be excused.
If you need me in the future, I'm here.
Thank you. All right, who are the parties on Casablanca?
Robert Mauer, and it's a Michelle case. It's a regular probation on a misdemeanor reduction.
Judge,
Who's
I'm
available to do it?
Marcus.
If I can say, I'm very happy you didn't say my name instead of
Well,
Denny.
I was gonna do that. But your name is not the first name that came up, so,
I was gonna get sick all of a sudden.
okay. All right, and then Andrew Garcia. If you could go to breakout room number 1, please, and they will let you know if they have all your paperwork.
Judge, quick question about tomorrow. What time's the panel coming up?
It's 9.
9, okay.
We're starting at 9.
I will be there.
All right, the court is calling 2021 CR 0153 Antonio Casablanca. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Robert Mauer for defendant, Your Honor.
And are you Antonio Casablanca? You're on mute.
I'm mute, Antonio.
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Casablanca, I'm going to show you what's entitled defendants consent to appear by video conference. Did you review that with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Mr. Casablanca, I'm sorry, just 1 second. I got another chat box. Mr. Hicks.
Yes, Your
I
Honor.
see your chat. The prosecutors have the ability to move people in and out of the breakout rooms. Right now, there's only one family violence prosecutor. So as soon as she's here and available, she will chat with you.
Great. Thank you very much.
You're welcome. We're back on the record. Mr. Bauer, I'm showing you what's entitled discovery acknowledgement. Did you review that have you reviewed all the discovery with your client and did you receive all the discovery in this case?
I did, Judge.
Court will find that state is in compliance with discovery. Mr. Casablanca, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney and did you understand it?
I did, Your Honor.
Counsel, do you waive the reading of the indictment?
I did, Judge.
State, it appears that you're proceeding on the lesser included offense of deadly conduct. Is that correct?
Yes, Judge, of count 2, waiving counts 1 and 3.
That's correct, Judge.
Any objection?
No, Your Honor.
Mr. Casablanca, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of deadly conduct as a Class A misdemeanor? The range of punishment is anywhere from up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I did.
Mr. Casablanca, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than a plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
Did you understand that it is within the court's purview and solely within the court's purview to determine the conditions of the conditions of probation? Did you understand?
Yes, Your Honor.
And did you understand that it's within the court's purview to determine the length of your probation? Did you understand?
Yes, Your Honor.
Right. Did you understand, according to the plea bargain agreement, the state is proceeding on count 2 as a deadly conduct. They're asking for a $1,000 fine to be probated. State recommends community supervision. They're asking for 1 year probated for 2 years, anger management, cognitive behavior, 100 hours of community service restitution, TAP evaluation, affirmative finding of family violence, and no contact with the victims in this case. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
No, Your Honor.
Judge, I'm gonna need a moment.
All right. All right, I'll send you to breakout room number.
And
4.
I'll probably need to talk to, is Michelle coming back on?
I'm not sure, but I tell you what, Mr. Maurer, let me meet you in breakout room number 6, and to the state, if you can come in to number 6 with me, please.
Okay, thanks. Sit tight, Antonio.
All right, Antonio Casablanca. Has he disappeared? Brenda, it surely is a Monday today.
I agree with that statement.
Yes. But you know what? As long as we smile, it'll be better. Let me see, where is Antonio? It is one of those days. Well, Andrew Garcia, who's the attorney for Andrew Garcia?
Judge, that's Miguel Nahera.
All right. To the clerks, if you could go to breakout room number 1 and make sure you have all the paperwork for Andrew Garcia, please. And then Robert Mauer. Robert Mauer. Brenda, I think I'm talking to myself today.
Phone problems. I was talking to my client. He said
Okay.
his phone overheated and shut down on him. He was calling, I guess, on his wife's phone, and I don't know if I should just have him show up in court tomorrow to do the plea, or.
Oh, just see if you can get him back because, you know, we have jury trials tomorrow.
Okay, give me a second. I'll try to get him back on.
All right, thank you. So the people on RC Curtis, when is this writ going to happen? And has it already been filed? The attorneys for RC Curtis, where are you?
Judge,
Yes. Yes.
I need a little bit more time to file it, Judge. I've been having medical issues and I've been in and out of the hospital off and on, so. But I'm getting up to full speed right now.
So when is this going to be done?
Give us 30 days.
All right, Norma, on RC Curtis, can I have a 30-day setting in the chat box? And this was for their writ hearing. All right, so here's the thing. The writ hearing is going to be set on May 2nd.
May what?
May 2nd.
Okay.
Okay. And Charles, I was looking for you.
I was taking a plea in the 290th while you were talking to others. I apologize.
Oh, no problem. All right, so we're going to come back on May 2nd for the writ hearing.
Okay.
All right, you all are excused.
All right. Thank you.
You're welcome.
Judge, my client's back on.
All right, thank you.
Judge, could you put me in a breakout room with Mr. Bunk?
Yes. Just give me one moment. I'll put you, Richard, I'm going to put you in breakout room number 4.
Okay.
And do you want your client there?
No, just me and Mr. Bunk.
All right, Mr. Curtis, you're excused. Okay, and Robert Mauer, we're back on your case.
Yes, ma'am. He should be. My client said he's on.
Yes, I'm here, Your Honor.
Okay.
I'm sorry, my phone, it said overheating and the app just turned off.
Well, I mean, let's not have a phone explode on us.
No, I have it on the AC now. It's because we were outside working on the fence, I think, and I left it in my jacket. I'm helping a buddy of mine do a fence, and during lunch I helped him do the fence, and I left it in my jacket. I think it had overheated then. Then I just jumped on the live or on the.
All right, well, let's get this done before.
All right, Mr. Casablanca, let's not it be said that you won't tell us your life story. I appreciate that. All right, so we're back on the record in cause number 2021 CR 0153. Mr. Casablanca, did you understand with an affirmative finding of family violence, you cannot be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Judge. I told Michelle I wanted to address you on the community service hours.
All right, state, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years and that there be parenting classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense of deadly conduct, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and its attachments.
Any
No,
objections?
Your Honor. No, ma'am.
Mr. Casablanca, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, but that's the way PSI. I'd like to address the court on the community service hours.
Yes, anything you wish to say on behalf of your client?
So, Judge, my client is on 100% disability. He was an EOD, I guess, explosive ordnance person in the military. He has a combined disability from both PTSD and a back injury.
But he's fixing a fence.
Judge, I'm just telling you,
I hear you. Okay.
The level of involvement in fence fixing. I'm just telling you what.
Okay.
So he stays home and takes care of his kids. And I'd ask the court to probate his community service hours or as much as the court felt was appropriate.
All right, Mr. Casablanca, how do you spend your time?
Most of my day, I'm here with my kids, and right now, I don't get my disability checks. So like my buddy, he's doing his fence. I just screw the screws in for him while he holds the wood, and he pays me a little bit by the day. So most of the time, I'm with my kids, my 2 boys, because my wife works. She works at the hospital.
And are these your 2 children with the complainant?
I have one with the complainant that we took her rights from her, and he
my
doesn't see
rights
her.
away.
nothing.
Nobody took my rights away. I signed my rights away.
Excuse me, no. Who is this speaking and interrupting a hearing? I want to know who it was.
That was the complainant.
Where's the complainant? Who is the complainant?
Right here.
What is your name? How are you listed on the screen?
Shayna.
Sorry, what?
Shayna. Michelle asked me to get on Zoom.
Nope. Let me stop you right there. Do you not realize a hearing is taking place?
Yes, ma'am, I do.
Why do you think that you can just interrupt a hearing?
Because that was incorrect information.
All right. Thank you very much. All right, Mr. Casablanca. With regards
Yes,
to the child with the complainant, who is that child?
His Jacob Rene Casablanca.
All right, and is he in your custody or no?
He's in mine and my mother's custody. Most of the time mine, because my mom is older.
Well, was there a custody agreement filed and signed through Child
There
Protective
was-
Services?
There was an actual custody battle. My mom got main conservator, I got joint conservator, but my mom has other children that are my brothers. So I take care of my responsibility, and I have Jacob most of the time. And she has him like whenever I go to work and stuff like that.
Judge, the complainant's rights were terminated.
All right, so was that the 12-year-old son?
No, it's somebody else. That's another
Right.
child. Yes.
All right, and so that is not the child that Mr. Casablanca is the father of?
Not with this lady. No.
My child is 4 years old.
All right, do you have any children with the complainant in this case?
No,
Just that one, right, Antonio?
just that one, but she has no attachment to him at all. No
Okay,
legal
Mr.
attachment.
Casablanca, when I asked you if you have any children with someone, that's either a yes or no. Do you have any children with the complainant who was just on this Zoom screen?
Yes,
All right, and who is that?
Jacob Rene Casablanca.
And the reason why I'm asking Mr. Maurer is because the state put in as a part of your agreement that he was not to have any contact with victims with an S.
I think the victim is supposed to be the 12-year-old. So in the car with the complainant was her 12-year-old son. I think that's what Michelle intended as the victims, not this child. The child that Antonio is talking about that he has with this young lady is not listed as a complainant. Antonio and his mom share custody, and the complainant has no rights to the child.
All right, so I'm going to put down then no contact. This is what the court is going to do. Court, as previously stated, is finding you guilty of deadly conduct, $1,000 fine to be probated. There's to be 1 year probation suspended and probated for 2 years, anger management, cognitive behavior, affirmative finding of family violence. There is to be no contact with Adrian Casares, and Shayna, Shana Ochoa. And there should be no contact with any children which Shayna Ochoa has any parental rights. That's the best way for me to word it. So if she has any children where she has some sort of custody to them, then you're not to have contact with them. She interrupted the hearing and said that she signed away her rights, which means she no longer has parental rights. You're telling me that she no longer has parental rights. Is that correct, Mr. Casablanca?
Yes, Your Honor.
Judge, I may need to ask for some clarity on that. I think the young lady has several other children, not the product of her relationship with Mr. Casablanca. So I just, and I don't know, when I know about the 12-year-old, I just don't know if we know about the rest of them. I want to make sure there's no inadvertent violation of his probation if we don't have a listing of the children.
I do not have a listing, and there's not a listing included. Mr. Casablanca,
Yes, Your Honor.
how long were you with the complainant? How many years were you together?
Not even a year, Your Honor.
Well, I mean, you had a child with her, so you should know who our other children are. You understand?
Yes, Your Honor.
Let that be a lesson to you. You shouldn't be in a relationship with someone if you don't even know who their children are. So I'm going to ask for parenting classes, 100 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining of those hours will be waived if you complete parenting classes, and you must complete those parenting classes. And the court is allowing that for you since your attorney has told me you have health issues. There's to be regular reporting by Zoom or in person. So if you can't report by Zoom, it's to be in person. I'm going to want random field visits 2 times per month. If you're drug tested today, what are the results going to be, Mr. Casablanca?
I'm going to come out positive.
What are you going to be positive for?
Marijuana.
All right, we're going to test you for levels. Proof of employment or SSI within 30 days. And there's to be no employment as a home health care provider with minors. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Casablanca, is there anything else that you need from the court?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, Mr. Casablanca, I'm going to send you to breakout room number 3. Probation will meet you there and go over conditions.
And Judge, the only other thing is I was told that there was victim impact statement, but
Yeah, there'll be no victim impact statement. I mean, you can't come in and interrupt a hearing.
I'd like to give some rebuttal on the victim impact statement if I could. We'll just leave that alone.
All right, Mr. Mauer, if you want to go in number 3 with your clients, you can go into breakout room number 3, or either do you have someone else with us?
No, Judge, I'm going to get ready for my fun trial with you tomorrow.
All right, we will see you tomorrow. Bye-bye.
All right, bye, everybody.
Judge, are you ready for me to go in there now, or do you need me to wait out here?
Yes, you can go in there now.
Okay, thank you.
Neil Kalfas, who are you having the bond hearing with?
Darren Does, and the other side of it is Michelle Hayden.
All right, just as soon as Ms. Hayden comes in, we'll take that matter up. Thank you for your patience.
Thank you, Judge.
It's a beautiful Monday. All right.
Really?
Yeah, oh yeah, it's gorgeous. Monica Guerrero, you have Mr. Garcia or Adam?
I have Adam Gonzalez, and he is there under the name Adam, and he's unable to unmute, and he's been with Lupe, and he can't seem to unmute to swear in.
All right, I'm going to see you to number 1. Ms. Ferguson, could you go to breakout room number 1 and help them out with his ability to unmute?
And then I need to have Mr. Tyshawn Harris, the amending of the bond conditions.
Okay. All right, just give us a moment. We're going to take care of your issue with and number 1. Ms. Ferguson has gone in there.
Thank you, Judge.
You're welcome. Scott Martinez, who do you have? Scott Martinez, who do you have?
Mr. Clark, Judge.
What's the first name?
Johnny Clark, case number 640955.
Criminal Trial Division or Family Violence?
I was speaking to Ms. Sparks.
All
CTE.
right. I'm going to send you to breakout room number 4. Tony Schiaretti.
Yes, ma'am.
Hi. Your case is being reset. Your client is your attorney's in trial. So just one moment. We're going to get a date for you.
Okay.
All right, Ms. Schiaretti, let me look at the calendar. We're going to bring you back on April 19th for jury trial.
Yes.
All right, thank you. You're excused.
Thank you.
Montez. Who are the parties on Montez?
That's Orlando and I, judge, with James and Miguel as pro temps.
Judge.
All right, and who is on Montez with you, Mr. Piddle? It's Ishimoto.
And Miguel Nanjara.
Okay. All right, what is happening with Mr. Montez?
You're here, Judge, on motions. Mr. Nanjara and Mr. Ishimoto were providing us with CVs on in regards to our witness list and our request for expert information. And so they have since tendered those CVs for their experts. There is a matter that we had discussed with them regarding our discovery, and we have a meeting set up on Monday to go through all their discovery. There were some missing, or at least one missing statement. And so we were going to go through his entire file to make sure that everything that they have, we have.
That is correct, Judge. I requested they come to my office. That way we can look at everything face to face, make copies of everything for them, whether they be electronic or hard copies. I just want to make sure they are in possession of everything that I have myself.
So that's going to be Monday, April 4th?
That's correct.
Correct, Judge.
I also understand, and correct me if I'm wrong, Miguel, but there's a report that you are also still waiting to receive.
Yes, the old firearms examiner has left in this case, Judge, so that a new one had been appointed and retested the material. We're making sure that we have that report to get to the defense as well.
Okay. So will it be done, or has it already been done?
My understanding is it should have been done. We just haven't gotten the report yet. Is that your understanding, Mr. Ishimoto?
Yes, it's my understanding that the firearms were retested. I just don't know if we have the report yet.
All right, so we're going to come back on April 18th. For any other motions in discovery. All right, is there anything else?
No, Judge.
All right, we will see you all then.
I get Easter Monday off, Judge? I guess not, huh?
What? Is it what? Did I give you an incorrect date?
No. The 18th is fine. My calendar has it as "quote unquote" Easter Monday, but I guess that's not an actual holiday. I guess my calendar's just reminding me it's the Monday after Easter for some reason.
Okay.
Maybe your children off. I think mine are.
Oh, okay.
Usually schools are closed.
Okay. That makes
See,
sense.
look, I'm saving people who can say, hey, I would love to be at home with the children, but I have court.
Sorry, I shouldn't be laughing at that.
Jesus rose on Sunday, Miguel. So
Touche,
All right.
touche.
I will see you all then on the 18th.
That'll be at 2 o'clock, Judge.
Yes.
I have to stick around, Judge. I still have Mr. Garcia's plea, and I believe Norma just let me know that he is in breakout room 1.
Yes. And do you all need to speak with Mr. Montez?
I'll speak with him briefly, Judge.
All right. Make sure he comes back to the main room, though.
Okay, Judge.
And I'll send you all to breakout room number 4.
Thank you.
Thank you, Your Honor.
You're welcome. Carl Basil.
Yes, Your Honor.
Yes.
I think that Easter Monday has to do with, I think the British, kind of like Boxing Day, I think, something to do with British.
All righty. So who do you have?
I have Mr. Juarez. I talked to him and I talked to Ryan this morning. I was appointed on this case a few days before the last court hearing, which was in February. So I haven't had a chance to go over all the discovery thing. I got tied up on some jury issues, jury stuff for the last week, but there's some videos I need to go over with them.
All right. So we're here because you're supposed to view a video.
Well, I was appointed a few days for the last setting, so I didn't have all the discovery yet then. I've got the discovery now, but I haven't had a chance to set up a conference or go visit with him to go over some of the videos he wants to see. Because I had a lot of, as the court knows, a lot of settings the last few weeks the jury's open. So I've got all the discovery though, as far as I can tell.
All right, Ms. Ferguson and Juarez, can I have a 30-day reset, please? All right, we're going to come back on April 26th. Let me make sure.
26. All right, I'll put it right there.
Yep, April 26th.
Got it. Thanks, Your Honor.
Thank you.
Have a good day. Enjoy. I guess next week's Fiesta, right?
Well, that's what they say.
Are you still having jury trials next week?
Yes, we are.
Okay, I didn't know. Usually they don't. So I guess that's why I got to be in the 437th then. So I'll be ready to go then. Okay.
All right.
Okay. Thanks, Your Honor. Have a good day.
Thank you. All right, Mr. Juarez, we're going to send you back. All right, Bertram Wood.
Good afternoon, Judge. How are you?
Great.
I'm here on Miss White. Kayla White did appear at 2 o'clock. She's in your courtroom. I'm just in one of these little ante rooms in your court. She has a warrant not for conduct since her case, but it's a newly indicted. So she needs to be magistrated. I had spoken with the DA about a bond. She has co-defendants. He suggested just set it at the same amount as her co-defendants. But having spoken with her, she's in a bit of a bind. She's not homeless, but she is indigent. And so I would ask the court to possibly set this for a bond hearing or maybe rule on a bond and let her try to get this resolved.
All right. Ms. White, if you can come up. All right, Ms. White, I'm going to give you your magistrate warnings. I don't know anything about the case. This is just me telling you what your rights are. Do you understand?
Yes, ma'am.
All right. So from looking at the documents that have been handed to me, you're charged with the offense of injury to a child with intentionally, knowingly bodily injury. You have a right to remain silent. That means that you don't have to speak to anyone. You have a right to retain your counsel or either have one appointed to you. Mr. Wood, are you appointed on this case as well?
I believe so, Judge.
If you can't afford to hire an attorney and you're indigent, one will be appointed to represent you. You will have a reasonable amount of time to speak to or consult with your attorney. You may have an attorney present if law enforcement or the state wants to interview you. You can have an attorney present at that time. Do you understand? If you start an interview with the state or with peace officers or police officers, you can terminate or stop that interview at any time. Any statement that you make can be used against you in a court of law or at your trial. If you're a foreign national, you have a right to have access to your consulate. If you want a court-appointed attorney, you'll have to fill out a form. If you need help filling out that form or that application, a clerk will help you with that. There are certain criteria to be eligible for a court-appointed attorney. I see no reason why you wouldn't receive one because you already have a court-appointed attorney in your other case. Once an attorney is appointed to represent you, they need to make contact with you by the next business day. So that will mean that your attorney would have to make contact with you by tomorrow at 2:53 p.m. if they're appointed today at 2:53 p.m. Do you wish to have a court-appointed attorney?
Yes, ma'am.
All right, and there's been no agreement on a bond amount?
No, Judge, my conversation with the DA was that their suggestion was just, there were co-defendants, and I think it's 30,000. So they suggested just keeping it the same. And I told him that sounded about right, but having then spoken with my client, she's in a different circumstance from the co-defendants in that she's now indigent.
All right, I'll set the bond at $30,000 for now. Mr. Wood, if for any reason she's unable to make that bond, you can always set it for a bond hearing and the court will hear it.
Thank you, Judge.
And you can set that as quickly as you wish. Ms. White, I'm going to hand you or have a document handed to you. The document is just a document stating that I've explained your rights to you and that you understand them. Do you understand? It's not an admission of guilt. Ms. Ferguson, I need a 30-day reset on Kayla White, please. All right, we're going to come back on April 26th.
Thank you, Judge.
You're welcome.
Judge, can Mr. Montez be excused? Me and Orlando conferred with him.
Yes, he may be excused.
Thank you.
Thank you, Judge. You have a good day, ma'am.
You're welcome.
And may I be excused, Your Honor?
All right, and there's just one other thing with regards, I'm going to do a no contact order.
Oh, sure.
And so there's going to be a no contact with Alexander White. I'm assuming that Alexander White is not with her, correct?
It's not my child. It was.
Right, I think that's, no, it's not her
That's the
child.
complainant, yes.
Yeah, it's not my child. He's actually in child custody right now, as far as I know of.
All right, do you have any contact with Brandon White, Christopher White?
Christopher White is my husband.
Are you all together?
We are separated at the moment as we had to give up our apartment. I don't know where he's staying. I'm staying at my boss's house because.
All right, there's to be no contact with Christopher White and Brandon White.
Yes, ma'am.
All right, if there's nothing else. You're both excused.
Thank you, Judge.
You're welcome.
Have a great Monday.
All right, you too. All right, Neil Kappas, you have been patiently waiting. Yes. Can you make sure you give a copy to me, please? Yes. Thank you. All right, who is the prosecutor? Is the prosecutor here on Mr. Kalfas's place, Darren Does?
Judge, this is Ryan. I'm not the prosecutor on this case, Judge. We've been kind of trying to handle the family violence stuff while Michelle is in a pretrial for tomorrow's trial. But this was the one that I kind of told her I don't know that I can handle just because of the situation. But I did tell her I would call her when this one came up and she can try to jump on real quick.
Okay, so if she's ready to jump on.
Okay, I'll call it.
All right, thanks. And then Roland Garcia, who are you here for?
Good afternoon, Your Honor. My apologies for coming in late. My client is Donald Gilliland. He is on bond. I'm not sure if he checked in this morning.
No, he has not. Deputy Laura, Deputy Mejia, is there a Donald Gilliland in the courtroom?
Oh, I see his name on the screen, Judge.
I'm here.
All right, what is happening with your case, Mr. Garcia?
Judge, last time I spoke with the state, they were checking to see if there was some additional discovery. I had spoke with Marcus Sanders regarding that. I'd given him a list of some items that I wasn't sure if they had been turned over to me yet.
All right, is there additional discovery, state?
Judge, I don't believe so, but if I could speak to Roland for a minute just to confirm that I looked for everything he was asking for.
All right, Mr. Garcia, I'm going to send you to breakout room number 3.
Thank you, Judge.
Leo Gonzalez on Moses Vargas.
Yes, Your Honor, we have a plea. I just need to get the paperwork from the court and also go over the paperwork with my client.
All right, if you'll put that in the chat box to Ms. Ferguson.
Okay, thank you.
And Vargas, I'm going to send you to breakout room number 4. And Leo Gonzalez, I'll send you to 4.
Thank you.
Joseph Appelt on Sanchez.
Yes, Your Honor. I've completed the plea paperwork, but I still don't have the consent to conduct the hearing via Zoom or the certification of the defendant's right to appeal paperwork. And I will have to go over all that with my client once received.
All right, I'm going to send you to breakout room number 5. Ms. Ferguson, if you'll go to number 5 with Mr. Appelt. Scott Martinez. Scott Martinez.
Yes, Judge.
What's happening with your case?
Mr. Clark, I've spoke to the state, spoke to my client. We do not have an agreement at this time, Judge.
All right, where's Mr. Clark?
He's in custody, Judge.
All right, Mr. Clark. Is this the only case Mr. Clark has? The one case?
Well, he has a parole hold, Judge.
All right, do you have all the discovery?
I believe so, Judge.
Has an offer been tendered?
Yes, Judge.
All right.
He has a parole hold until May, early May,
Okay.
if that makes any.
No, it does not. Mr. Clark, we're bringing you back on April 4th. That's your plea deadline date. After that date, you'll be set for a jury trial.
Yes, Judge.
Thank you. Monica Guerrero,
I'm present, Judge. I am present.
and you have Adam Gonzalez.
I do.
All right, we'll take that up. Mr. Kalfas, you have so much patience in your pocket, and I greatly appreciate it. I'm just waiting for them to zoom in, okay?
That's fine, Your Honor. I patiently will wait.
Oh, thank you. All right, who's the prosecutor on Adam Gonzalez?
I can do it, Judge. It's Ryan.
Thank you. Is this your client, the one who has Adam and the graffiti behind him?
Yes.
All right, the court is calling 2021 CR 0392, State of Texas versus Adam Gonzalez. Can I have parties announced for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
Monica Guerrero for Mr. Gonzalez.
And are you Mr. Gonzalez? Mr. Gonzalez, you need to unmute yourself.
Oh,
Are you Adam Gonzalez?
yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
None from the state.
Any objection from the defense?
No, Your Honor.
Mr. Gonzalez, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
I did.
All right, Mr. Gonzalez, could you step back from your screen a little bit? All right, thank you. Court will find the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
I did.
And did you electronically sign it? What?
Yes, ma'am, I did.
Ms. Guerrero, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving the enhancement allegation at the bottom.
Any objection?
No objection. No objection, Your Honor.
Mr. Gonzalez, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years of life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Oh.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, The court could find you guilty and sentence you up to life in prison and up to $10,000 fine. Did you understand? I'm sorry?
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be set at a cap of 7 years in the prison. There's an affirmative finding of the deadly weapon. The state opposes your application for deferred adjudication. There's to be restitution of $3,000 to La Tienda, Tienda Food Mart. There's to be no contact with Tharun, Tharun, Kadada, Kandada, or La Tienda Food Mart at 627 Couples Road. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
I'm sorry,
No
what?
contest. No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State would offer State's Exhibit number 1 and all attachments to the court.
No objection, Your Honor.
All right, Mr. Gonzalez, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Again, did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing said documents, the court finds that there is sufficient evidence to find you guilty. However, the court is deferring finding of guilt as you apply for deferred adjudication. Ms. Ferguson, could I have a sentencing date for Mr. Gonzalez? And he obviously will need a TAP evaluation. All right, we're going to come.
Gave you back May 2nd. Did she give you May 2nd, Judge?
She gave me May 23rd.
Oh, okay, May 23rd. Sorry, I can't see with talking on the Zoom.
All right, so we'll be back on May 23rd. Mr. Gonzalez, I'm going to have you speak with probation, so they'll let you know what needs to be done. The court will make a decision on your application based upon the report I received back from probation and any other information that's presented to me. Do you understand?
Yes, ma'am.
All right, Mr. Gonzalez, I don't know what's going on with your life, but it seems like you need to go to AA or NA meetings, okay?
Okay.
You look completely different from the way you looked in your photo when you were arrested. I'm going to send you to breakout room number 3. And Ms. Guerrero, you can go to number 3, or either if you have anyone else with us.
I do. I need to have that hearing for Tyshawn Harris that's still been on the Zoom.
Okay. Is that family violence or criminal trial division?
Family violence, because Miss Hayden looked up some information.
All right, Mr. Gonzalez, I sent you to a breakout room. You need to go to breakout room number 3.
Judge, for clarification, was that a PSI and TAP?
Yes.
Okay, thank you.
You're welcome. All right, we're going to take up Does first, and then we'll take up your case next, Ms. Guerrero.
Thank you.
All right. And I believe the bond motion was for cause number 2022 CR 0493. Is that correct, State and Defense?
I believe so. It's for the
murder?
Yeah, the murder case, 0493. And it's a continuation of, we started this hearing a couple weeks ago.
Yes, no, I remember. Yeah. All right, so we're going to go back on the record in 2022 CR 0493, State of Texas versus Darren Paul Does. And we're here for the defense. The defense is requesting bond, and Mr. Does, I believe, has been remanded without bond. Is that correct?
Correct, Your Honor.
All right, if I could have parties announced for the state.
Michelle Hayden for the state.
For the defense.
Neil Kalfas on behalf of Darren Does.
All right, and are you Mr. Does?
Yes, Your Honor.
All right. I believe where we left off, there was going to be more information, or maybe somebody wanted to present more information to the court. Is that correct?
Correct, Your Honor. I tendered I know I tendered a copy of a non-prosecution affidavit on the assault case to Ms. Hayden. I believe that went to the court. If it hasn't, I can get it over there now. But and then I also have one brief witness that I'd like to tender to the court and tender for cross-examination. Ms. Marceau, Julia Does Guillory, who's present here in my office whenever she's called upon to testify.
All right, so with regards to the waiver of prosecution, did you send that to the courts, or through electronic service?
Let me check on that, Judge. And I know that Michelle Hayden got a copy of it, and I assume that when we sent it to her, that we also sent it to the court.
All right, because the court hasn't received it.
It was sent to me a couple weeks ago.
Judge, would you like for me to send it now?
Yes, please.
Okay. Where do you want me to send it exactly?
I will put my email in the chat box to you. And if you could include Ms. Hayden in that email, please.
Okay, Judge, it's on its way.
Okay. All right, and then while the court is waiting to receive that, you have a witness? Mr. Kalfas, while the court is waiting to receive that, you have a witness?
I do, Your Judge. I apologize. I didn't realize I was on mute. The defense would call Marceau Julia Does Guillory.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, if you can lower your hand and state your name for the record, please.
Marceau Julia Does Guillory.
All right, defense.
Ms. Guillory, where do you currently reside?
12526 Upton Park.
And who do you live there with?
My daughter.
And are you currently employed?
I am.
And where are you employed?
South Texas VA healthcare system.
And what do you do for South Texas VA healthcare system?
Infection preventionist.
And how long have you been so employed?
5 years.
And prior to that, where were you employed?
The Department of Defense.
And how long were you employed with the Department of Defense?
Since 2001.
And how are you related to Mr. Darren Does?
He's my son.
And how many children have you had?
4 sons.
And it was Ronald Does also your son?
Yes.
And when Darren is given a bond, or if he's given a bond and released on bond, where will he reside?
At one of my homes.
And does he have transportation? Does he have a vehicle?
He does have a vehicle.
And does he have a job?
He does have a job.
Has he, for the better part of his adult life, stayed gainfully employed?
Yes.
Is he intelligent?
Yes, he is.
Are you confident that any instructions or rules that this court imposes upon him, he will follow?
Yes.
Are you concerned at all about whether or not he will show up for court when required to show up for court?
No concern.
Do you think he's a flight risk?
No.
Do you personally feel like he's a danger to the community?
No.
Have you and I discussed his bond situation?
We've talked about his bond situation.
Have you talked to Darren about his bond situation?
I have.
Have you talked to others about Darren's bond situation?
Not, I would say not in particular. Only basically it's just myself and you and Darren.
And what is your desire with regard, your personal desire, understanding that the judge is a very seasoned veteran and will make the interest that's in the best interest of the county. But what's your personal desires with regard to Darren getting a bond? Do you want him to get a bond?
Yes, I'd like to get a bond.
And do you want him to get a low bond?
As low as possible.
And when you say as low as possible, do you have have you helped Darren out some financially through this process?
I have.
Has it had an effect on your finances?
To a degree.
Has it affected his finances?
Definitely.
Have you had some communication with Nikra, the alleged victim in the family violence assault case?
The last communication I had with her was in December of 2021.
And without getting into too much of the particulars of that, just how would you describe your relationship with Nikra?
We actually have no relationship. I really don't know her personally. At one point, I was getting some things out of Darren's apartment. One, I went to look for his Chase computer. It was gone, completely gone. Some other items were gone. And I actually reached out to Nikra and I asked her what were these items.
Judge, I'm just going to object to hearsay, also relevant.
All right, that'll be sustained.
We'll pass the witness, Your Honor.
All
No
right.
questions of this witness.
All right, and the court is in receipt of the affidavit of non-prosecution. The court hasn't opened it yet. Any objections to the court reviewing the affidavit of non-prosecution from NICRA?
Not for purposes of this hearing only.
No objections from us, Your Honor.
Court is ruling what's titled affidavit of non-prosecution for NICRA Dole. Is anyone asking that this be admitted into evidence for purposes of this hearing only?
We would ask that it be admitted for purposes of this hearing only, Your Honor.
State?
Judge, I don't have a problem with for purposes of this hearing only.
All right, then this, I will forward this to the court reporter. And it will be attachment listed as defense exhibit number 1. All right, the court then has reviewed defense exhibit number 1. Any other witnesses defense?
No, ma'am, Your Honor.
State any other witnesses?
No, Your Honor, just the evidence that was submitted into evidence the last time and the testimony that we presented last time from the pretrial bond officer.
All right, defense, it's your motion. I'll hear your argument.
Your Honor, we had argued last time, but we would just reiterate our arguments. We're asking the court to set a bond at $150,000 or as close to $150,000 as the court deems appropriate, or lower. He's already he'll have 2 bonds now. He has had ample time in the Bexar County Jail to reflect and consider his situation. The murder case, the facts of the murder case are very favorable to a self-defense argument. There are witnesses that I don't believe that any investigators or anyone with the state has talked to. I feel confident that when he gets his day in court, that he will do well in the murder case. And unlike some other defendants, he has a place to go to. He has a job waiting on him. He has a vehicle. If the court is going to impose GPS on him, we would ask for partial GPS so that he is allowed to work. And we just would, I guess, would reiterate our earlier arguments and ask the court to set the most reasonable bond the court sees appropriate.
All right, state.
Judge, our argument remains the same. Whether or not defense has a particular defense they're going to be able to present is not really an issue for this bond hearing. Grand jury found there was probable cause for murder. And as the court has the prosecution in this prosecution guide in this case, I'm sure the court's read that Ronald Does, our victim in this case, as he's dying, says, "My brother shot me." The defendant shot his own brother, which the evidence supports resulted in his death. As we talked about the last time, when he was on bond, full house arrest for murder, he left his house without permission. He also picked up a new offense, and whether or not our victim is cooperative right now, he was involved in a physical altercation, and he was again arrested, and he's got a pending case for assault, family violence, and assault pregnant person. The state does believe he's a flight risk due to his previous judgment for evading arrest and detention, and the fact that he left the scene of the shooting and wasn't arrested for days later. He also has previous history for violence against family members. His assault married cohabitating judgment that was entered into evidence. So the state is concerned about him living with family members. We're concerned that he continues to pose a threat to the community, victim's family. We're concerned about the aggravating factors in this case, the fact that he didn't comply with his original bond conditions. And so for those reasons, we would ask that you continue to keep him remanded.
All right, defense, it's your motion, so you'll have final argument.
Your Honor, with regard to leaving this house without permission, when the pretrial testified about that, she said that he he was admonished about that there wasn't even a violation report filed on that was from an incident where he had a family member that was in an emergency need of assistance, and he was gone from his house for about 15 minutes. And so we would just remind the court or argue to the court that after that, he stayed completely compliant except for this alleged assault situation. That on the assault situation, Darren was the one that actually called law enforcement, that the complainant is signed that non-prosecution affidavit. And just for the record, that's not a non-prosecution affidavit that me or my office got. That was a non-prosecution affidavit that was obtained by a court-appointed investigator working for one of his prior court-appointed lawyer. The complainant in the affidavit in the assault cases is not cooperative with the state, is my understanding. And there is no member of the defendant or the defendant's family that's complaining to the DA's office or urging or trying to push this murder case forward that I'm aware of. Actually, quite to the contrary. His brother, Ronald Does, had a more violent and a more volatile history than Darren Does has ever had or ever will have. And I think that the facts of the case or the weight of the evidence against Mr. Does ought to be a consideration of the court, just like a lot of other things. If it's likely that a person is going to get found not guilty, then it should have some weight, maybe some minor weight, but it ought to have some weight.
Judge, I'm just going to object to this line of argument and all the hearsay that's coming in about evidence that hasn't even been presented and what kind of defense.
Well, the court has the non-prosecution affidavit, and presumably the non-prosecution affidavit has that stuff or doesn't have that stuff. And so,
all right, the objection will be overruled.
At any rate, I'm asking the court, based on the totality of everything that the court has heard or not heard, to set the most reasonable bond that this court believes is necessary under the circumstances.
All right, thank you. All right, defense's motion will be denied. The defendant is remanded without bond. This case will be reset for April 25th. Mr. Kalfas, if you have all the discovery and you wanted set sooner, just let the court know.
All right, Your Honor, and just I'll file a written motion for speedy trial, but I'd rather have the case tried sooner than later if he's going to be remanded without.
And Judge, there is still outstanding discovery that since the last hearing, we provided a lot to defense that we were waiting on, but we're still waiting on some medical records and some EMS records. So.
All right, Mr. Kalfas.
Yes, ma'am, Your Honor.
If there's still outstanding discovery on April 25th, then the court, you can always refile your motion for bond.
Very well, Your Honor, but just for the record, this case is almost a year old, and if they're just now getting some discovery, then that's somewhat of an issue for the state, but we'll deal with it.
There's also some ballistic testing that I think we're waiting on.
All right, so counsel, if the discovery, if you don't have all of the discovery by April 25th, then you can refile a motion for bond.
Judge, how
court
about
is always open to consider it.
I'd rather be in the posture of, I mean, that's, the state can't just let this discovery filter in. I mean, how long are they going to have to get their ballistics and to get their discovery together?
April 25th.
All righty, Judge. I'll see you on April 25th.
All right, thank you.
Maybe excused?
Yes. Do you
Thank
need
you.
to speak with Mr. Does or no?
Yes, briefly.
All right, make sure that he comes back to the main room after you speak with him.
You want me to come back as well?
You just need to make sure your client comes back to the main room.
Okay.
All right, I'll send you to breakout room number 1. All right, who are the parties on Andrew Garcia?
That's me, Your Honor, Michelle Hayden.
You got to knock it up for the defense, Judge.
Good for you.
All right, the court is calling 2022 CR 2948, State of Texas versus Andrew Garcia. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Miguel Nájera for the defense.
All right, and are you Andrew Garcia?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Garcia, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am. Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Garcia, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family choking, strangulation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am. Yes, ma'am.
All right, just one second. All right, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
I believe he has a rational as well as a factual understanding of the charges against him.
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,500 fine. I'm sorry, $1,200 fine. State recommends deferred adjudication. They will take in consideration County Court Cause number 679393, JN number 2059843. There's to be a TAP evaluation. Following the recommendations of TAP evaluation, the BIPP course, affirmative finding of family violence, UAs, 120 hours community service restitution, and no contact order with the victim. Did you understand that it is within the court's purview to decide conditions of probation? Did you understand?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State is at the plea bargaining agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your deferred adjudication be for a term of 6 years. There'll be a TAP evaluation and 120 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Into the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
And then I had to put all that stuff in storage.
How do you plead? Guilty, not guilty, or no contest?
Guilty.
So forth, so on.
State any evidence to support the defendant's guilty plea.
Kate, for State's Exhibit 1, its attachments and evidence.
Any objections?
No objections, Judge. We've reviewed those documents.
Mr. Garcia, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state was calling the right to remain silent?
Yes, ma'am.
Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same.
You know,
yes,
something where I could get overall issues and maybe something that really I don't have, because I would have came to a crack at over 6 years ago when I got out of homelessness. So
after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we would like to waive PSI.
Anything you wish to say on behalf of your client?
Your Honor, I would just ask this honorable court to please follow the plea bargain agreement.
Mr. Garcia, do you have any children?
Yes.
What are their ages?
I got an 8-year-old, 7-year-old, and a 6-year-old.
Who's the mother of those children?
Melanie Adames.
Do you have any children with Selena Flores?
No, ma'am.
How often are you using drugs?
I used to buy stuff this year, since last year, basically. So I was only doing it for like 2 years.
6 years old, I've been through it.
And what drugs were you using?
That's synthetic marijuana.
When's the last time you had employment?
I'm still employed right now.
Doing what?
A movie company.
You really shouldn't be in somebody's home. And when you say moving company, is it in somebody's home?
Yes.
All right, so you really shouldn't be allowed to be in someone's home because you have drug issues. You understand?
Yes, ma'am.
So how far did you go in school?
I only made it to 9th grade.
Why?
I dropped out because I had my kids and I was just trying to have my baby mama finish and she finished. And
Let's say the mother of our children. Let's not say baby mama.
Oh, sorry about that. My mother and my children. I let her finish school and then I just stay home and watch the kids and just take care of my family, basically.
Well, that's another thing that's going to stop. You're not babysitting. When is the last time you had contact with these children?
Last time I was in, before I got in here, it's like a month and a half.
So basically, you've been seeing them for a month and a half since before you were arrested. Were you babysitting them?
Yes, I see them every day.
Well, that's going to stop. Because here's the thing, you have a drug problem. So you can have contact with them, but it's going to be supervised. You're not going to be babysitting. You understand?
Yes, ma'am.
Sitting here for a whole nother 6-7 months, dead time, and then finally get out there, I go another 6-7 months, 8 months, 9 months, and the whole year long.
All right. So this is what the court is going to do. There's a $1,200 fine that'll be probated. 6 years deferred adjudication. Taking consideration County Court Cause number 679-393, JN number 2059843. The BIP reports there's an affirmative finding of family violence. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the vaccination, but if you do, 40 of those hours will be waived. CPS compliance, if applicable. So if CPS is involved in your life, then you'll need to do what you need to do for CPS. There's to be parenting classes with compadre y compadre. If you complete the parenting classes, the court will waive the remaining of your community service hours. There's to be no contact with Selena Flores. Your relationship with her is over. You don't have any children with her, so there's no reason for you to see her. So there's to be no contact with Selena Flores, proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors. I'm going to want field visits, random, 2 times per month. No unsupervised contact with minors. Regular reporting by Zoom or in person. Regular UAs and intensive outpatient treatment with probation. Rebecca, is there anything else that Mr. Garcia needs?
No, ma'am.
Mr. Garcia, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, Mr. Garcia, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Garcia, good luck to you. You're going to have to do better. You understand?
Yes, ma'am.
And
Judge,
Mr.
I would just ask-
Nahara? Yes, no problem.
I was just gonna ask if after he does his parenting classes and if he's coming up clean on his UAs, would you reconsider his ability to?
Yes, that's what I was just going to tell you. So I want him to have some classes underneath his belt so that I can see what's going on. All right, Mr. Garcia, I'm going to send you to breakout room number 2. And probation will go over conditions with you. Mr. Nahara, you can go to 2 or you can remain.
I'm gonna join him over there, Judge. May I be excused from there?
Yes.
And Michelle, will you get those dismissals and rejections in?
I already did.
Oh, okay, awesome. Thank you.
All right, everyone, just give me a moment, please. All right, Ms. Ferguson, on Sherry Cooper. All right, well, as soon as they get to me, we'll talk about that. All right. Monica Guerrero.
Present, Your Honor.
Yes. And which one do you have?
Tyshawn Harris. On your docket, it says Talia Harris.
Is her case indicted or no?
It is not indicted, Your Honor.
All right. So what is happening with Ms. Harris?
Mr. Tyshawn Harris is present, Your Honor, and would like to address the court as to why he needs the GPS removed.
Okay.
And if the court is going to consider keeping GPS on, that it be tracking only and waive all fees.
All right. State, are you opposed to the request?
Judge, we're not opposed to waiving fees. We think at this time, I mean, this case is pretty young. It involves an allegation of a gun. I just sent State's Exhibit 1 to defense and to the court. We think that tracking is still a good idea and necessary at this point in time.
All right, Ms. Guerrero, then it appears that the state is in agreement to tracking and waiving fees.
Okay, my client really wants to tell you that he does not want to be on GPS at all.
Okay, all right, the court, Brenda, you ready? Court is calling NITMAG number 650463, State of Texas versus Talia Harris. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Monica Guerrero for Tyshawn Harris, known in court as Talia Harris.
All right, and are you Mr. Harris?
Yes, ma'am.
All right, you're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Harris, any objections to us proceeding by video?
No, ma'am.
All right, defense, you filed a motion?
Yes, I'd like to call Tyshawn Harris, please.
All right, and what is your motion? The motion is to
My
amend
motion-
bond conditions?
Correct, Your Honor.
All right, state, have you had a chance to review defense's motion to amend bond conditions?
I have, Your Honor.
Are you ready, state?
Yes.
All right, defense, it's your motion.
I'd like to call Tyshawn Harris, please.
All right, Mr. Harris, if you can raise your right hand for me, please. You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Could you spell your first name for the record, please?
My first name is Talia.
All right. Defense?
And Mr. Harris, you now go by the name of Tyshawn Harris, is that correct?
Yes, that's the name I'm trying to change my name to. Yes. No.
Okay, and you are asking the judge to remove the GPS tracker, is that correct?
Yes, ma'am.
Can you please explain to the judge why?
Yes, ma'am. Because I mean, I work and I'm trying to go to school, and the victim, I don't even really know him, and I was in the house, like I wasn't even outside when all this took place, and like she stated, it's known that it was a gun present, but the gun was it's registered to my name. And the only reason why I went and got my gun is because the victim was pointing a gun at the door when I opened the door to look for my girlfriend and tell her to come finish cooking for the kids. So and he had it pointed at me, but I know I did not discharge my weapon or nothing like that. Like he been harassing me since I got with my girlfriend, and I don't even know him. Like I really don't know him at all. I don't.
What relation does he have to your girlfriend?
He's my girlfriend's baby child's father that come over there beating up on her stuff. But I just don't get in that. I just mind my business because that's not my place. That's not my business.
And at this point in time, it's fair to say that you never knew this man.
No, I don't know him. I'm not gonna lie. I know his name because he used to date one of my other ex-girlfriends, and he assaulted her, and they got some stuff going on. So that's how he know of me, and that's how I know his name. But I don't know him physically. Never met him in person. Never been around him. I don't know him like from nowhere, like at all.
So he dated an ex-girlfriend of yours and your current girlfriend right now.
Yeah, he got a child with my current girlfriend.
So how does that apply to you having this GPS monitor?
Cause I don't live nowhere near him. I don't be worried about him. All I do is go to work, come home and I just do my own thing. I'm not in the streets. I don't sell drugs. I don't do nothing. I just go to work. Like, I don't feel like I need to be bound to a house because I'm not a flight risk. I'm not gonna run. I didn't assault him, so I don't have nothing against him. Like, so, like, I just feel like I should not be bound to the house. Like, I don't do nothing but go to work. And it's like me being bound to the house is stopping my second job. Like, so I can't do nothing. And I can barely pay my bills and pay where I lay and feed myself.
Okay. And being on the GPS has been inhibiting your ability to work.
Yeah, because the job I work now is only Monday through Friday, and my second job is every day, and it's an overnight job. And I don't have my diploma, but I'm trying to get my diploma so I can go do my EMT at SAC. So SAC got diploma classes, GED classes. So I'm trying to get my stuff together.
What is the second job that you do?
I work for home health care. I've been working there for 4.5 years.
Okay. And the regular job that you have Monday through Friday?
Monday through Friday, I work for the Texas Health and Human Service Commission for healthcare benefits and SNAP benefits.
Okay.
And then I just got hired for Hulu April 26th to work at the Hulu call center.
Okay. At this point, are you able to afford the $300 a month for the bond and for GPS?
Not on top of me having to pay where I lay and pay for my food and my phone bill and stuff. No, I don't have it because I'm not able to move around to my second job. If I had my second job, yes, I would be able to afford it, but I can't afford it. I just can't. I pay where I stay, half the rent here, lights, bills, like, can't afford it.
I'll pass a witness, Your Honor.
Okay.
Just a couple questions. So it sounds like you did point a gun at the victim in this case. Is that correct?
No, I did not point the gun. The gun was on my waistband.
That's what you just said a minute ago.
I apprehended my gun, but I didn't point it at him. He had a gun pointed at me and my girlfriend at the door. And my gun was on my waist side. And he seen it. But other than that, I did not pull it out, point it at him. I didn't do none of that. He had a gun pointed at us.
I believe you said that's why you got out your gun.
Yeah, that's why I went upstairs and got my gun because he had a gun pointed at us. But when I came downstairs, I didn't have it in my hand. I put it on my waistband.
Well, it sounds like you're changing your story. You were previously granted deferred adjudication for resisting arrest in 2012. Is that correct?
Yeah.
And also theft, 50 to 500. Is that correct?
Yeah, those cases got dismissed.
Well, I mean, after you did your deferred adjudication. Is that correct?
Yeah.
Okay. No other questions.
All right, any follow-up?
No, Your Honor.
All right, any other witnesses, defense?
No, Your Honor, I rest.
State, any witnesses?
No, just we'd offered State's Exhibit 1, its attachments into evidence for purposes of this hearing.
No,
Any objection? All right, State's Exhibits 1 and attachments then are admitted. Court will hear argument.
At this time, Your Honor, based upon the testimony of Mr. Harris, the difficulty in paying the GPS has been exacerbated by the fact that he cannot work the second job because there's restrictions on the hours that he can work, which are Monday through Friday. We're asking that the court remove the GPS because it's causing a tremendous hardship. And if the court is not inclined to remove the GPS, then I would be asking for tracking only and waive the fees.
State.
And Judge, we're fine with waiving the fees. And our issue is we don't think, given the nature of this offense, what he's been arrested for, an offense involving threats using a firearm, that we think it's premature to remove the GPS. We have concerns about the safety of the community, safety of the victim involved in this case. So we'd ask that he remain with the GPS.
All right, any objection to tracking?
Your Honor, we just ask there's no contact with the victim in this case.
All right, this is what the court will do. The court will not remove GPS. The court will alternate man conditions to include tracking only for GPS. So Mr. Harris, you are free to move throughout your employments and take as many jobs as you want to. The court will waive the GPS fees, and there's to be no contact with the complainant. Do you understand?
Yes, you talk about Mr. Anderson, the man I don't know, right, Judge?
Yes, that
Okay,
person.
now I'm just making sure. I'm just trying to make sure because I don't want. I'm just making sure I understand everything. That's all. Just being thorough. That's all.
No problem. Yeah, no, it's good to make sure that you know who it is. So you're not to have any contact with him. You understand?
Yes, ma'am. I don't never wanted no contact at all with this situation. Like,
All right. And if the complainant comes to your home or comes near you, call the police.
yes, ma'am.
All right. Is there anything else?
No, ma'am. I appreciate you.
Oh, thank you so much. I appreciate that. All right, then, Ms. Guerrero, do you have anyone else with us?
No, Judge, I think I cleared up the majority of my docket with your case.
All right. Have a great rest of your day. Happy Monday.
Thank you, Your Honor.
All right. Bye-bye. Nathan Slimane.
Good afternoon, Your Honor.
Good
I'm here to approach on something off docket that's by agreement. There's an individual who is in custody remanded on a possession 1-4. I have conferred with Joe Ray and we're in agreement on a bond amount and condition, and I wanted to see if we could, or if I could approach on that very briefly.
Yes, if you file the agreed motion with the court, then the court will sign it.
Okay, I'll do that then.
All right. Thank you.
Okay, thank you, Judge.
You're welcome. All right. Who are the parties on Juan Montemayor?
That's my case, Your Honor, William Davidson.
You're right for the state, Judge.
Okay, this is a indecency case.
Make sure that phone doesn't go.
Yes, Judge, I'm helping out.
Okay, I just want to make sure.
Yes, ma'am.
I'm used to you being on that side, but.
I'll approach the judge in the front. Oh. Okay. No, you want to be next to me? I could approach the judge. Okay.
All right, where is Mr. Montemayor?
Your Honor, the bailiff is taking us out of the witness room here and bringing us to the front of the courtroom. So that's where we're going right now, okay?
All right, thank you.
Thank you.
All right, the court is going to call. All right, the court is calling 2021 CR 10593, State of Texas versus Juan Montemayor. Can I have parties announced for the record for the state?
Joe Garcia.
For the defense?
William Davidson.
Are you Juan Montemayor?
Yes, ma'am.
We're proceeding by video. The court will note for the record that the defense and the defendant are in the courtroom, but we're proceeding by video due to the pandemic. Any objection from the state?
None, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Montemayor, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication. Did you review that with your client? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Oh, I'm sorry. I got a little bit distracted. Just one. Everyone, just give me a moment. All right, we're back on the record. Mr. Montemayor, I'm showing you what's entitled defendant's application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Mr. Montemayor, did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Montemayor, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Montemayor, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with indecency with a child by contact? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Montemayor, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. The state is remaining silent on your application. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yeah.
Then, Mr. Montemayor, to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No context.
State any evidence to support the defendant's plea.
State out for State Exhibit 1 and its attachments.
Any objection?
No, Your Honor.
Mr. Montemayor, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly, voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachment and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. We will be back on May 23rd for the court to make a decision on whether or not I will grant your application for deferred adjudication. It will be based upon any evidence that's presented to me in the PSI report that is completed by probation. Do you understand, Mr. Montemayor?
Yes, ma'am.
All right, so you'll need to be in court in person on May 23rd at 9 a.m. Do you understand?
Yes, ma'am.
All right, thank you. I'm going to see you to a breakout room.
Thank you.
And to the courtroom, if you could go to breakout room number 1, and probation, if you could go to number 1, please.
Judge, I'll be right back.
Thank you. Albert Charis, Jenny Cooper.
Your Honor, I'm present. Is Albert going to go or no?
I'm here, Your Honor.
Okay.
I just need to approach on an off-docket matter, and I'll be happy to wait for those who are certainly ahead of me today.
Okay, because what I'm going to tell you is the off-docket matters, we only have 1 family violence prosecutor today.
I see that. I'll be happy to hang out and just wait, Judge.
All right, thank you.
Thank you.
All right, Albert Charis, who do you have?
I have Deangelo Robinson.
And what is happening with Mr. Robinson?
Your Honor, I'm asking for bond reductions on 3 cases that he has pending in this court.
All right, who are you conferring with?
Mr. Sanders.
All right, just give us a moment. The court reporter will be right back and we'll take that up. And then who are the parties on Moses Vargas and Emmanuel Sanchez?
Brittany for the state, Judge.
Joseph Appel for the defense on Emmanuel Sanchez.
All right. And then Roland Garcia on Donald Gilliland.
Yes, Your Honor.
What is happening with Donald Gilliland?
I conferred with Mr. Sanders on this case, and there's still 1 item of discovery that he was going to double check on to see if there is additional discovery still outstanding.
Mr. Sanders, what's the update on that?
Yes, Judge, there was one thing that I forgot that he asked me to look into. I provided Roland with everything that we have, but there was one thing that, I guess there was 1 disk that had a lot of discovery on it, and I need to double check that it was on that disk. And so I told him I would be in the office again tomorrow and I can confirm that it was on there.
All right, Ms. Ferguson, Donald Gilliland, can we reset this for the week of April 4th, please? For discovery. All right, we'll come back on April 4th.
Thank you, Judge. You will be excused.
Yes.
Thank you. Have a good day.
Thank you, you too. And everyone, just give us a moment. We're just waiting for the court reporter. Oh, and I say her name and I only say it once and she appears.
I'm Baptist.
All right. Just 1 second, everyone. All right, we're going to take up Emmanuel Sanchez. Court is calling 2021 CR 6429, State of Texas versus Emmanuel Sanchez. Can I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Joseph Appelt.
And are you Mr. Sanchez?
Yes.
We're proceeding by video because of the pandemic. Any objection from the defense or the state?
I'm from the state.
None from the defense.
Mr. Sanchez, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all of the discovery in this case and did you review it with your client?
Yes, Your Honor, I believe I have.
Court will find that the state is in compliance with discovery. Mr. Sanchez, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Sanchez, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days in the state jail facility and up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court doesn't have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has shown to be factually and rationally aware of what's going on and has been able to discuss the charges and relevant fact pattern with me.
All right, Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Of course not.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Judge.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility. There's a $0 fine and no applications. Did you understand that to be the plea bargain agreement?
Yes, Judge.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge, I do understand.
Counsel, have there been any such motions?
No, there have not.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty, I did it.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and its attachments.
No objection, Your Honor.
Mrs. Sanchez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I do understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, everyone, just give me one moment, please. All right, state and defense, it appears that part of the paperwork, I think, got cut off from the printer because we've been having issues with our printer. So is there any objection to the judgment in 250129 being printed? State?
None from the state.
Defense?
And none from the defense, Your Honor.
All right. And after reviewing state's exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
If it pleases the court, yes, Your Honor, we would waive a PSI.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Sanchez, he does have a couple of priors, as the court knows, that's been alleged in the indictment, and he is here today before you to take responsibility for his actions, and you heard him in his plea. Guilty, I did it. And so for those reasons, we ask you to accept and follow the plea bargain, which is the minimum time for a state jail felony, Your Honor.
All right, the court will follow your agreement, sentence you to 6 months in the state jail facility, give you credit for any time served. Mr. Rodriguez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Mr. Sanchez, that was right.
Yes, Mr. Sanchez.
Yes, I reviewed it and I agree with it.
All right, did you sign it and understand it?
Oh, yes, I signed it and
And did
understand
you-
it.
All right. Because this is a plea bargain agreement, because the court followed your plea bargain agreement, and because you waived your right to appeal, you do not have permission to appeal. Do you understand?
Yes,
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
of course.
If you have a question over what a weapon or ammunition is, you will need to contact an attorney. Do you understand?
Yes.
All right, Mr. Sanchez, good luck to you. Do better, okay?
Thank you, Your Honor. May I be excused?
Yes, you may be excused. Have a great
you.
rest of your Monday.
Thank you.
May I be excused too, Your Honor?
Yes,
Thank you, Judge. Have a great day.
thank you. All right, who are the parties on Moses Vargas?
That's me, Your Honor.
And Brittany for the state judge.
All right, the court is calling 2022 CR 0697, State of Texas versus Moses Junior Vargas. Just one moment. I'm sorry, could I have the parties re-announce, please, for the state,
Brittany Sparks.
for the defense?
Leo Gonzalez.
And are you Mr. Vargas?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Vargas, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review that discovery with your client?
Yes, Your Honor.
Court will find that defendant has knowingly, I'm sorry, just one second. All right. All right, the court will find that the state is in compliance with discovery. Mr. Vargas, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Vargas, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with cruelty to non-livestock, torturing? Just one moment. All right, torturing, and that's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vargas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine probated. There is no application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, MIG-MILF evaluation, follow all treatment recommendations, and no ownership of any animals. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, Judge. State offers States Exhibit 1 and all attachments.
Any objections?
No objection, Your Honor.
Mr. Vargas, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, there is a, this is an instance where this individual had shared custody of this pet. There was some issues arising from the behavior of this pet that led to this incident. He does understand the situation that evolved during this time. He does take responsibility. He does also understand that there was subsequent incident regarding this pet, and that pet has been put down. And at this time, he understands that the severity of what happened.
Okay, but what about the stabbing of the dog?
Your Honor, that was related to what he believed at the time may have been the dog attacking him. There is some dispute as to how that occurred, and those are things that could have been brought up at trial. And based upon the facts, he has decided it is his best interest to follow it.
All right, Mr. Vargas. Mr. Vargas, how often were you using meth?
Not that often. I don't do it a lot. I haven't been doing it. I have been doing pretty good, actually.
Okay, but how often were you using it?
Really for work. It was mainly for my body, to be able to work. Cheaper to get that than get prescriptions. I didn't even have a doctor. Go see.
I've never heard of meth being used as a pain substitute, but okay. So again, how often were you using meth? You still haven't answered my question.
Not often. I'm not where I was.
What does that mean? I wasn't.
I just do like a couple of lines here and there. And that's it. I'm not smoking it or shooting
But
it.
it's a couple of lines here and there. What does that mean, Mr. Vargas? I'm not with you when you use meth, so I don't know how often you're using it. You're on mute, Mr. Vargas.
It was. I mean, it was. I'm not a drug addict. I was a working man. I barely used it. It was just like I said. Just
again. I'm not with you when you use it. So what does barely mean?
maybe 2-3 times a week.
Okay. Have you ever been diagnosed
Not that I know
for any type of mental health issues?
of. Not that I know of.
What do you mean, not that you know of? Have you seen a doctor or
I-
not seen a doctor?
I've seen a doctor, but I never found that there was anything wrong with me.
All right, was it a psychiatrist? You're on mute, Mr. Vargas.
I think it was an evaluation.
All right, do you have any children?
Yes, I do.
What are their ages?
I have older ones that are 35, 32, 31. And then I have one that's 15 and one that's 19 years old.
All right, who does the 15-year-old live with?
His mother?
Are you involved?
No, I'm not.
All right, this is what the court is going to do. The court is finding you guilty, will sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine, probated, 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to obtain the COVID vaccination, but if you do, 40 of those hours will be waived. NIC mouth evaluation and TAP evaluation while in custody. And you're to follow all TAP evaluation recommendations. There's to be no ownership of any animals. Do you understand?
Yes, Your Honor.
So that's right down to a goldfish. You can't own it. You understand?
Yes, Your Honor.
All right. There's to be regular reporting by Zoom or in person. We'll do a referral of felony drug court as well. Random UAs upon release. And field visits 2 times per month random. Rebecca, is there anything else he needs?
The proof of employment, Judge.
Thank you. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors. Mr. Vargas, is there anything else you need from me in order to be successful in this probation?
No, Your Honor, that's fine.
All right, Mr. Vargas, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, Mr. Vargas, good luck to you. I hope this helped you. I'm going to send you to breakout room number 1. Probation will go over conditions with you. Mr. Gonzalez, you can go to 1 or you can be excused.
Thank you, Your Honor.
You're welcome. Who are the parties on Deangelo Robinson?
Judge, are you ready for me to go in there? Or do you need me to wait out here?
Oh, no, you can go in there.
Okay, thank you.
Judge, I'm on Deangelo Robinson.
And
Our
Marcus.
DA is Mr. Sanders.
All right, court is calling 2021 CR 9974B, 2021 CR 9973B, and 2021 CR 9975, State of Texas versus Deangelo Robinson. Bad parties announced for the record for the state,
Marcus Sanders.
for the defense.
Albert Chidas for Mr. Robinson.
And are you Mr. Robinson?
Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Robinson, do you have any objections to us proceeding by video?
No, ma'am.
All right, the defense has filed motions requesting a bond reduction. State, have you had a chance to review those motions?
Yes, Judge.
Is there an agreement or no?
No, Judge.
All right, defense, it's your motion. You may proceed.
Yes, Your Honor. I have filed motions to request bond reductions on the 3 cases. I've also asked the court, in the event that the court reduces the bonds, to request to waive the GPS fee associated with what would probably be full house arrest. I have talked to the family. I've talked to the mother, the father, regarding the amounts of each bond. They're at $65,000 each. And we've done the math, and they might be able to do 10,000 each. Since the court would require full house arrest and a leg monitor, GPS monitoring, we would, in the event that he was released, ask that he be residing with his girlfriend on full house arrest. And she is also honored. She was when we first started. She should still be on. Let me double check real quick here.
All right,
Yeah,
so
she's
here's
on.
the court's question. I see that these are 3 different cases, but
2
is
separate
it all
incidents.
for one incident?
It's 2 separate incidents, Your Honor. The ag robberies are one incident, and the aggravated assault with a deadly weapon is a separate incident.
Okay. Any other evidence, Mr. Charis, or just argument?
I would like to call, I don't know if the court wants to indulge. I know it's late. I would call Miss Lockett, that's his girlfriend, just to verify that she can provide a place to live, that she would comply with whatever's necessary. I think his mother was on at one point. I'm not certain if she's still on, but she could provide assistance as far as anything the court needs in terms of keeping him in compliance. He's 19 years old. If he's on house arrest, he's not going to be working. He's not going to be leaving the house. So I don't know if you need to hear from Ms. Lockett, or it's sufficient just that she's here and she's willing to.
Yes, I'll note that she's here, but here's my main concern, Mr. Charis.
Yes,
and
go ahead.
Mr. Robinson, I'm not taking any of these cases as true because the court hasn't heard any evidence. But I have 2 aggravated robberies and 1 aggravated assault with a deadly weapon. And the aggravated robberies are alleged to have taken place on May 19th. And the aggravated assault is alleged to have taken on May 9th. So again, I'm not taking any of this as true, but I have a charge from May 9th, 2021, which is an aggravated assault. And then thereafter, I have the aggravated robbery cases. So that's the court's concern, Mr. Charis. And I have cases in close proximity.
And yes, Your Honor. And just for the court's consideration, I am not making application on another case that is in the same court on the domestic violence side with the DAs in the domestic violence court, because there's not a bond set at 65,000. So I think the family, I've talked to family about all the pending cases, and they think they can hopefully manage it. But I wanted to let the court know there's also a family violence case, not with the girlfriend. It's alleged that he had an issue with his sister, but that's a separate matter.
And what date what's the alleged date of that offense?
That, let me check real quick, Your Honor.
December of 2021.
That's, yes, Your Honor. And there is a misdemeanor case from November of 2020 for an unlawfully carrying a firearm case. That's pending out of County Court 8. And that is a separate matter, again, different court. But I just want to let you.
And what is the CM 093573? What case is that? Does anyone know?
That is the family violence with his sister case. That's the December 1st case.
Okay.
I I am informed by the state, and they copied me about an hour ago. And when I talked to Mr. Sanders, I think it was last week, he did tell me that there is another case that is sealed and pending, but hasn't been charged, hasn't pulled up on the system. That is an aggravated assault, which is a completely different incident. And again, that hasn't even been charged, but just out of, just to let the court know, that's out there. And I don't know if it will be indicted, if it will not be indicted. At this point, I don't have a whole lot of information other than what I got from Mr. Sanders about an hour ago. But he hadn't mentioned it at our meeting.
Right.
I know it's a lot, Your Honor, but we don't, I have had a chance to review everything that is currently available to me. And although it looks horrendous, it is not a situation where we know for a fact that he did something or didn't do something. There are a lot of issues with all these cases. We come to find out that he had nothing to do with 2 or 3 of these cases. So I would ask the court to lower the bond so that he can at least be home. He's 19, he's obviously. I'm sorry.
I'm 18. Just to clear that up. I'm sorry.
Oh, sorry, I'm corrected. He's 18 years old. He's a young man. I think that if he's on leg monitor, it'll serve the state's interest. And I know that there may be a concern about the public and the safety of the public, given the severity of these charges. I've explained to my client that it's in his best interest to cooperate, to not do anything foolish. If the court does lower his bond and his parents go to great lengths to pay his bond, I would just ask the court for that reduction so that he can be at home, so that he isn't sitting in county, and for that matter, at taxpayer expense. And again, I would ask the court, if he is granted a reduction and the family can afford the bond, I would ask for a waiver of the GPS fees, because as it stands, his bond fees will be considerable. I think at this point, they're topping close to $11,000 out of pocket for the family, and that's just beyond their means.
All right. In each of the cause numbers, the GPS fees will be waived, but the motion to reduce bond is denied. Ms. Ferguson, can I have a 30-day reset on Deangelo Robinson, please? Ms. Ferguson, can I get a 30-day reset on Mr. Robinson, please? All right, we're going to come back on April 26th.
Yes, Your Honor. Thank you.
Thank you. Do you have any issues with discovery or anything?
I think it's just very early on. These cases have been indicted, or 3 of them have been indicted, but they were all sealed cases. So we just barely found out about him recently. He got picked up earlier this month. I think it was maybe the 10th or so.
Okay.
So
all right. Thank you, Mr.
Yes, Your Honor.
All right. Thank you, Mr. Charis. We'll be back then on April 26th. And if there are some discovery issues, just let the court know.
Yes, Your Honor. Thank you.
All right. Do you need to speak with Mr. Robinson or no?
Yeah, if I could just go into a breakout room briefly.
All right. If you'll make sure he comes back to the main room, please.
Yes, Your Honor.
I'll send you both to number 3. Bobby Gibbia.
Good afternoon, Judge. I'm here for Sherry Cooper.
Hi, what is happening with Ms. Cooper?
I'm ready for trial and I'm happy to confer with the state.
All right, I'll send you to a breakout room. I will tell you, Miss Kathy Compton is not going to be available till after April 7th, but I'll send you to breakout room number 4.
Okay.
Albert Charles. I'm sorry, Alfonso Otero.
Good afternoon, Judge.
Good afternoon. Who do you have?
Kathy. Charles.
All right, what is happening with this case?
I have some medical records I want to provide to the state. I just confer with Michelle about it. The family has the medical records in the courtroom and they'll be dropping them off today. So I can scan them and share them with the prosecution judge. We can get a reset for that purpose.
All right, Ms. Ferguson, can I have a 3-week reset on Kathy Charles? Charles Kathy, please. All right, we're going to come back on April 19th.
April 19th. Thank you, Judge. May I be excused?
Yes. To the courtroom, did Anthony Davis show up in the courtroom?
Who was that, Your Honor?
Anthony Davis?
No.
All right, thank you. Jenny, keep it.
Yes, Your Honor.
All right, Ms. Hayden, Ms. Cupid says she has an off-bond matter. I'm sorry, off-docket matter. It has truly been a Monday. I'll
But
send
you
you
know
to
what?
breakout.
It is about a bond matter.
Yes, I'll send you to breakout room number 2.
Thanks.
Jerry Kagan.
Judge, I have on the screen, he's listed as Ramses Ramos. I believe your docket has him as Valentine Ramos.
Yes.
So Valentine Ramses. If we can get a record with Mr. Gromer.
All right. Ryan Groomer.
I'm here, Judge.
All right. And Ms. Ferguson, Mr. Robinson can go back. And Mr. Groomer, Mr. Kagan said he'd like to speak with you.
Okay,
Mr.
I may bring
Kagan?
Joe Ray with me too, because I think he was working on this one for me. So, but I'll jump in there.
All right, I've sent you to number 3. Eduardo Jimenez.
Yes, Judge. First of all, apologies for the fish tank behind me. It's making that bubbling noise.
Oh, that's okay. But are you taking care of the fish? That's most importantly. Is the tank clean?
I'm sorry, I couldn't hear you, Judge.
Are you taking care of the fish? Is the tank clean? Is the water recycling?
It's not my fish, Judge.
Okay.
It's the landlord's fish.
All right. It appears to be a little, the water appears to be
It
sort of
does.
cloudy.
It looks a little, it's all kind of, fizzling out. It needs some energy. So today we had Isaiah Gonzalez, and I was trying to, I don't know if I got my point across or not, that we had already filed a motion for continuance that was ready to go for you. I think Robert Luna had it in his possession. And that was, the reason for that was that there were some witnesses that we hadn't been able to get in touch with. And then Melissa said she was okay with, or Michelle, I'm sorry, is it Michelle, the prosecutor? Said that she was not going to oppose that and she was okay with that. But then you said show up 9 o'clock tomorrow morning. I said, yes, ma'am, I'll be there. And I still will be there 9 o'clock tomorrow morning. But I was just wondering about the motion for continuance. I was wondering why you didn't want to rule on it, today.
Because I'll see you. A lot of things can happen between one day and the next.
Yeah.
So I'll review that on Tuesday.
Tomorrow. Okay, no
Yes.
problem. But I was told that you wanted to talk to me about something, or?
No.
Well, I was just called your office and I said, because I had a text that you wanted me to zoom back in, and I just talked to your office.
Which
and
one is
somebody
this for, Miss Ferguson?
Yeah, I'm gonna put something in the chat.
All right, just give me a moment. Yes, this is what's going on. Your client said that he hasn't spoken to you about clothing for trial and that he has no clothes to wear.
Okay. Well, let me put in a clothing order for him, and I will go visit him. Okay.
All right. Thank you. I'll see you
All right,
tomorrow.
thank you. Yes. Goodbye now.
Thank you. Bye-bye. And Mr. Lopez,
Yes, ma'am.
all right, who's your attorney?
Excuse me,
Mr. Hicks.
Bob Hicks.
All right. Just give us a moment. Is this going to be a plea? Does anyone know?
Judge, I think this is the one where he said it's an MTR, but he was trying to come back another day. But I didn't confer with him.
All right, Ms. Ferguson or Mr. Lopez, recall it for tomorrow. And Ms. Cupid, your off docket matter.
Yes, Your Honor. I had appeared last week. I had Mr. James Cole. I know you have many cases, but you might recall this is my individual who's driving the truck from Colorado.
Yes.
And so a warrant went out when he did not appear for trial last week. On his way back to Texas, he was held by the state of Colorado when they ran. He went through some checkpoint with his truck on this warrant. And so now he's in a situation, he wasn't charged with anything in Colorado. And I'm asking, would the court consider lifting that warrant and give me 48 hours to get him back to the state of Texas?
State.
Judge, if he was there on business and, this was, defense says they've got documentation, we don't have a problem with that.
Defense provide me with documentation. I know this was set for a jury trial.
It was, Your Honor. And even documentation from his employer that he was on business. I can do that.
Yes.
I will do that, Your Honor. Do you want me to just send it to Norma when I get it?
Yes, please.
I will do that, and I thank you for the consideration.
All
Thank
right,
you,
you're
Michelle.
welcome. And just file your agreed motion.
Okay. All right, thank you, Judge.
You're welcome. Hi, Bobby Gebbia, you're back.
I am back, Judge. I just switched over to my home computer here. We did confer, Marcus and I, and we agree that this is a case that should be set on the jury trial docket. We are ready for trial, both sides. We can certainly accommodate Ms. Compton the best that we can.
All right, Ms. Ferguson, can I have a jury trial date for Sherry Cooper, please?
May I confer with my attorney? Judge?
All right, Mr. Gebbia, Ms. Cooper would like to speak with you before she gets her jury trial date.
All right.
I'll send you to breakout room number 2. All right, everyone, our last person is Bobby Gebbia. And Jerry Kagan.
Yes, Judge.
Yes,
So-
what is happening with your client?
I spoke with Mr. Groomer, and he and Assistant District Attorney Garcia are going to try to work diligently to try to straighten out this discovery problem. But as of right now, we're still waiting for videos.
All right, and what is the problem?
Okay.
State,
And
why
that's
don't
why-
you have the videos?
And that's why I wanted to put it on the record.
Judge, yeah, there's something wrong with the JN number or relating to the uploads on Coban. Apparently the wrong videos were uploaded. It was some other defendant. I had them re-uploaded and it's still the same issue. I'm not sure why, but it may be where we can just get them on a disc and give them to defense. But right now it's pulling up as the wrong video and uploading as the wrong person.
All right, so, but State, you do have the disc?
No, I don't have those yet, Judge.
So you don't have any of the discs that's related to this defendant?
No, there's no disc. I just had the digital form, which was the wrong person.
All right, so you don't have it in any digital form that's related to Mr. Ramos. Am I correct in saying that?
That's right, Judge. Something's wrong with it.
Okay. So when are you anticipating having this?
If we can get a regular reset, a 30-day reset, I should have everything solved. Reach out to the reporting officer and try to get the correct disc from them directly.
Okay, and who indicted this case?
Let me see. It looks like intake Michael Cohen.
Okay. All right. So what I'm going to do, because I've given you all a reset date for discovery from February 24th. So I'm going to give one more setting for discovery. And then after that, Mr. Kagan, if you wish to proceed to jury trial or have a hearing on the lack of discovery, and depending on the ruling on discovery, it may be something the state will be allowed to use or maybe not allowed to use.
And there is one more thing. I forgot to mention this to the prosecutor, if I could just throw it out there now. I'm not opposed to working out a plea bargain in this case. I just cannot sign that discovery acknowledgement. So if the court would allow me to do it without signing that discovery or a modified discovery acknowledgement saying,
I mean, you need discovery. All right, Ms. Ferguson, can I have a 30-day reset on Mr. Ramos, please?
It's in the chat already, Judge.
All right, so we're going to come back on April 26th.
very good.
Thank you.
Thank you.
Thank you, Judge. Can I be excused?
Yes, you may be excused.
Thank you
All right, Bobby Gibeon Cooper.
very much. You have a great day.
Oh, thank you. You have a great day too.
I'm here on Sherry Cooper, and I think if Marcus is available, I'd like to talk to him again.
All right, Marcus, if you can go to the breakout room with Mr. Gebbia.
I'm assigned
Number 2.
to 2, yes.
Can everyone just give me a moment? I know it's 5:07. Yes, Mr. Gebbia.
Good afternoon, good evening again, Judge. For Sherry Cooper, it turns out that we have a bond situation and we'd like to ask for PR bond. The state is opposed to that. However, having just conferred with Miss Sherry Cooper, she is about to have a baby like any minute. She says maybe 2 weeks the latest. Now, if we were to give her an emergency PR bond, we could get her out of the jail, get her back to her doctor, get her back to her facility, get her back home, install the GPS device on her. I'd ask for reinstatement of her bonds as they were before, but it may be too far gone for that. And if just considering the nature and the circumstances of her pregnancy, which I failed to do before when I asked for a trial date, I think it's probably in everybody's best interest to get her out and get her into a hospital before we have a baby there at the Bexar County Jail.
All right, and what is she charged with?
We have identity theft, maybe some methamphetamines. Let me get you all of her information. Right now, I'm showing 3 pending cases out of your court, Judge. 2021 CR 0664.
All right, that's an unauthorized use. Then she has a tampering with government record, and then fraudulent use or possession of identifying information.
Those are the three that I'm currently showing online.
All right, state, are you in agreement?
Judge, we are not on the oldest case, the UMV. There were at least 2 occasions where she failed to appear. There's a third time where I couldn't tell if they just got off the bond or if she also failed to appear. So we're not in agreement on a PR bond.
All right, defense, if you want to file a motion, the court will hear that motion and hear evidence. Ms. Ferguson, could you give me a date to have a hearing on Ms. Cooper? If the state is ready, we could probably hear it tomorrow afternoon. All right, we can come back. Norma is put in the box April 4th. So we can hear it on April 4th.
Okay, Judge, if that's the soonest available, that's okay. There's nothing I could do about that. I am available tomorrow afternoon, should there be an opening.
All right, be sure to confer with the state. It's just that we're doing a jury selection tomorrow. And I'm unsure how long that's going to go.
I understand. I did one this morning.
Oh, and are you still in jury trial?
No, I'm not. My role was only for the jury selection. Others are taking over evidence from there.
All right, we'll see you back then on April 4th.
Thank you, Judge.
All right, thank you. Ms. Ferguson,
Thank you, Judge.
Mr. Cooper can go back. Thank you, Ms. Cooper, for your patience. And we're going to stop live streaming. We'll be back, Brenna. We have jury trial